Welcome back. Before we get into our conversation, we want to update you on one of our top stories. Sarasota and Manatee voters going to the polls today to decide whether or not to increase their own property taxes to spend on education. Let's take a look at some of the results here in Sarasota County. By an overwhelming margin, Sarasota voters have voted to increase their millage rate for money to go to the schools in terms of extending the day at school. And also in Manatee County, that referendum has also passed by a narrower margin, voters voting by 51.36% to increase the millage rate. These are unofficial numbers, and of course we will be updating it throughout this broadcast and tonight coming up at 11. And back to our conversation. Whoa. Sheriff's deputies storming into a Florida's man's home and taking his weapons and 267 rounds of ammunition against his will, and no protest. That's because this was the first ever usage of Florida's new red flag legislation signed into law after Parkland. It permits police to confiscate guns from people deemed a potential risk to themselves and others, and it prohibits them from buying weapons and ammunition from any source until they can prove to a judge that they do not pose a risk. It marks a rare point of consensus between gun control and pro-gun advocates. And joining us for more is Ed Brodsky, state's attorney for the 12th Judicial Circuit, Jeff Young, known locally as the gun lawyer, and Kurt Lavarello, executive director of the School Safety Advocacy Council. Thank you all, gentlemen, for joining us tonight. And Jeff, let me start with you, because as I said, it seems a rare point of consensus that people have been talking about for a long time, but only now has become Florida law after that terrible tragedy in Parkland. Do you think this could have been passed before Parkland?
Maybe. I had actually never heard of this concept until after Parkland. Obviously, I'm familiar with the domestic violence injunctions and things of that nature. But after Parkland, I saw on Facebook people were sharing articles about this concept, and I actually shared it myself and said this is actually a pretty good idea. So could it have passed beforehand? I don't know. I just don't think a lot of people knew about the concept, and I don't know if it ever even been proposed or discussed. So I can't really answer that question.
Ed, what has been the problem for prosecutors and police officers before now in terms of removing firearms from those people who maybe close friends and family or neighbors believe posed an imminent risk?
I don't think we had as strong a tool as we do now. I think that Florida's on a heightened state of alert right now. I think that when tragedy hits home, as it did here in our backyard, I think that there's an immediate reaction. And we don't want to see our children, and we want to make sure that our community's safe and our kids are safe. And now we're giving law enforcement and our courts the tools that they need to make sure that dangerous individuals don't have firearms.
What was the legal impediment?
Well, I think that that there is stronger mechanisms in place now that weren't in place previously that allowed the courts to much more swiftly act. And this legislation that was now passed gives the authority of the courts to allows officers to search for weapons, seize weapons, and allows law enforcement officers to go into a residence where they believe that there's firearms and weapons and to remove those.
Kurt, you study school safety and you travel the country on this issue. You saw Keith Fitzgerald in our report say that if this law was in effect previously, this may have prevented Parkland. Do you agree with that?
I do. Actually, looking at some of the cases that the Broward Sheriff's Office handled leading up to the shooting, it looked like there were a couple in which the law enforcement officers' hands were tied. And I, as a former school resource officer myself, I can tell you there were countless times we'd be in a school and we wanted to take action, but our hands were tied and not able to do what we'd like to do in terms of eliminating the risk. So I think this law, along with some of the mental health provisions of the new law, will give us some new tools.
Are there two issues here? Number one, the limitations of the law, but also the documented failures of law enforcement in Broward County?
Well, there's no doubt some documented failures in that case all across the board, and being from Broward County, that would hit a little bit closer to home. But certainly, I think this new law will help us, especially in the school setting.
Okay, we have to take a quick break. We're getting warmed up, and we'll have much more on red flag legislation right after we check the first alert weather. Stay with us. Welcome back. We're talking about Florida's new red flag law, and joining us for more is Ed Brodsky, state's attorney for the 12th Judicial Circuit, Jeff Young, known locally as the gun lawyer, and Kurt Lavarello, executive director of the School Safety Advocacy Council. So let's tell folks a little bit about the first person in Florida who came under this new red flag law. He was a 54-year-old man from Broward County who told officers he was targeted by the FBI and burglarized. And officers said that when they entered his home on a welfare check, they found evidence of voluminous amounts of notes containing numerous references to former President Barack Obama, that Obama was killed in the 1980s but came back now to murder children, to place their spirits into the man's head, and that I guess he's saying that Obama was a member of Al-Qaeda. Ed, if this set of facts was given to you or police before this law went into effect, what could you do with it?
Well, I think previously what would have had to have occurred is law enforcement would have had to have had a probable cause to believe that the person was committing a crime, and what they would have done is then ask the court for authority to obtain a search warrant and then search the residence. Where now here they believe that he's a danger to himself or to others, and they can petition the court for a risk protection order, and the court can authorize it.
And Jeff, what, as far as you are aware of, is the procedure? Let's say this gentleman here is taken away and he's Baker acted and he receives treatment. What would he have to do to get his firearms back?
Well, I think in answer to your last question, they wouldn't have necessarily had to get a search warrant for a crime. They could have Baker acted in, which they did in this case as well. And then if he gets a civil commitment, an actual judge orders that he stay longer on his Baker Act, that would make him a prohibited person, which would mean he wouldn't be allowed to buy firearms, et cetera, after that anyway. But with this new law, that gives them one extra thing that they can do. So in this particular case, they get the injunction. The person is supposed to voluntarily turn in their firearms. If they refuse to voluntarily turn them in, or if you think they have more firearms than what they told you, then you can seek a search warrant and go into the home and remove any firearms that you have. Basically, he's now entitled to have a hearing. The court has to have a hearing where he can come, and the state has to prove, law enforcement has to prove by, I believe it's clear and convincing, that he's a danger to himself or to others, and they need to take these guns. And then if they do that, the injunction stays in place for a year. He is permitted at any time during that year to apply to get his guns back. The burden would then be on him to go to court and prove that he's now fixed, he doesn't have any of these issues, and he can get his gun back. That's generally what the procedure is. Now, this case is a clear case. It's clear by the facts of this case that this person would fall under this statute. Our concern in the gun community is when you have cases that aren't so clear, when you get gray area cases where somebody isn't necessarily thinking that an ex-president came back from the dead, but maybe they're just a little depressed, or maybe they're a little concerned about with their work or whatever. So I'm concerned about how it's going to be applied to everybody as a whole. This case is quite clear. Let's see how it shakes out when you get more gray area cases down the road.
Right, because Kurt, a lot of people who may have mental health issues have not been adjudicated by a court of law that they have that. So, are you concerned that up until now, people who should not have been having a firearm in the house have had it, and that this law really kind of deals with that as completely as needs to be done?
Absolutely. We can, we'd put special watches on people all the time in the law enforcement community, especially in the school setting where we knew a young person had, mental health issues, and we knew that the house was full of guns. It was always a concern of ours, and we made certain that we'd focus on this young person when they came to school. And so this law does provide us an extra tool to see if something like that could be prevented.
I'm wondering here when we're talking about this, that some people are fine until they're not. There was a situation up in Pasco County, I believe. A retired police captain got into an argument with a guy during the previews of a movie because he was texting his daughter. This was a police captain, and they got into an irrational debate over texting, and the guy is dead here. You're okay until you're not, and this kind of law doesn't seem to be able to address that.
Well, there's no law that would be able to address that. I mean, that situation I don't think was a mental health issue. The guy, as you said, was a retired police officer. There was no indication that he had any kind of violent history or would have any problems with his gun. That's your standard road rage style incident that happens, and there is no law that would be able to prevent something like that. If you have a law like this where you have somebody with clear evidence that they have mental health issues, the Baker Act was there before. Now the Baker Act is still there because I think you're going to see a lot of these work together in conjunctions just like they did in this previous case. But now the person wouldn't necessarily get their guns back once they just get released from the hospital. There's an extra step that they have to do so.
This is an important question, Ed, because, and I have seen situations like this play out, and police have said there has to be an imminent threat to doing yourself or others harm. That's, you know, what do you mean by imminent? How imminent does it have to be? If you saw that somebody within the last couple of months have made some kind of suicidal threats?
Well, they've established two standards. One standard, if you're applying for an order without having a hearing before the court, where the law enforcement has to show reasonable cause to believe that the person poses a threat to himself or to others. And, you know, mental illness, violent behavior, those are all factors that are going to be considered. If it now goes to a hearing before the court, then the court will have to present clear and convincing evidence to show that this person presents a danger to himself or to others. And there's a number of factors that the court will consider that I think are relevant to the issue for the court to decide whether the person needs to have these weapons taken away from them.
Like what factors?
Well, they'll include whether there's been a history of substance abuse, whether there's been a history of domestic violence, whether the person's been convicted of any incidents involving the threat or use of a firearm, you know, stalking, incidents of prior stalking against other individuals.
Yeah, the statute actually lays out, as I said in my segment, it's actually a pretty well-written statute. It actually lays out a lot of different factors that the court is to take into place, such as a lot of things that Ed listed out there. So it's pretty clear what they're looking at.
Kurt, what about the gray area that Jeff is talking about, that some cases, many cases, may not be as clear-cut as the incident that we just cited here, and who makes the decision whether or not that this behavior is worthy enough to remove firearms from someone's hand?
Sure. Well, I think the one thing we have to keep in mind is that this is one tool in this big toolbox called this Marjorie Stoneman Douglas Act that was enacted as a result of the tragedy that happened in Broward. So there are some good things in that law, the way it was written, that will aid us in law enforcement and school safety. But there are also some things in there that will detract from school safety, in my feeling, such as arming the civilians in schools. I think that passed along with this, and I think that brings up a real problematic approach, especially when we're requiring 132 hours of training for a civilian to now carry a gun in our schools in Florida. We require over 1,000 hours to be a barber in Florida. So I think there are some things that can also lend to the opposite side of the equation as well.
That sounds like a whole other show that we'll have you back for. But Jeff, sure. let me ask this tough question. We only have probably less than a minute left here, but what happens, God forbid, if there is a teacher that discharges a firearm because of a perceived threat in the classroom and hits a child, and there's an argument made that the training wasn't enough?
Oh, they'll deal with that at the particular time. I mean, I obviously disagree, and I'm for more armed people in the schools, whether they're school resource officers. I mean, we just had a shooting in a school today that was stopped by an armed person at a school, happened to be a school resource officer. But I think that's a pretty adequate amount of training. I mean, no offense, but a lot of law enforcement officers probably don't spend that much time on the range getting their certificates on shoot the firearm. So again, that is a whole discussion for another day, but I mean, that's just one part of the law.
We have to take a quick break, and we'll be back for final thoughts in just a moment. Stay with us. And our guest joining us right now for final thoughts. And Ed, I know you think this is a good law, but it's not the be-all, end-all. It doesn't solve, obviously, all the problems that we have out there with gun violence. No,
I think this is an outstanding piece of legislation, bipartisan effort between the two houses, and the House and the Senate on both sides. And this is going to go a long way. There's a lot of different pieces to this bill, from education to mental health to providing ways to anonymously report suspicious behavior, to giving law enforcement the tools that they need to more proactively prevent gun violence. This is a very strong effort for law enforcement, a very powerful tool, and I think it's going to make a difference.
And Jeff, I know you overall support the bill, although there are some concerns, but what kind of feedback have you gotten in the pro-gun community in terms of concerns about this legislation?
Well, I mean, there's two separate issues. The legislation, there's obviously certain parts of it that we are adamantly opposed to, the raising the age of 21, mandatory rating periods, banning of bump stocks. I mean, gun owners are adamantly opposed to those. As far as this specific red flag legislation goes, like anything else, I think the concept is good. I'm just curious as to see how it's going to be used effectively. As a defense attorney, as a civil libertarian and a gun owner, we're always concerned when you give the government more authority to come into your home and do things, whether it's remove stuff or arrest you or search for items. So our initial concern is always abuse by law enforcement or the judges to use these for nefarious means. So I just kind of want to wait and see how it plays out.
And Kurt?
Well, I would agree, with Ed and Jeff, in that this is a definite step in the right direction. However, I'd love to see this discussion not at the hands of another tragedy. This is something we should be discussing 365 days a year, not just when something like that happens.
Hear, hear. Gentlemen, thank you very much. FYI, you can watch past discussions on demand. They're available on Apple TV, Amazon Fire, and Roku. And for the latest on local breaking news, don't forget to download the updated version of our app. If your current app doesn't work, it's expired. Just go to the App Store and re-download it by searching for WWSB or My Suncoast. We want to thank all our guests for being here tonight. Ed Brodsky is the state's attorney for the 12th Judicial Circuit. Jeff Young is known locally as the gun lawyer. And Kurt Lavarello is the executive director of the School Safety Advocacy Council.